Senate Judiciary Committee will come to order, and we'll ask the Secretary to call the roll, please.
Chairman Murphy.
Here.
Senator Shockley.
Here.
Senator Essman.
Here.
Senator Ogier.
Here.
Senator Blewett.
Here.
Senator Hinkle.
Here.
Senator Hutton.
Here.
Senator Gent. Senator Larson.
Here.
Senator Moss. Senator Peterson. Senator Vincent. Thank you.
Thank you. Welcome, everybody. This morning is dedicated to a hearing on Senate Bill 423, which the committee has been trying to come up with as a somewhat middle ground, and it's a work in progress. Remember that. It's we'll spend if we need it, we'll be able to allow an hour and a half for testimony from each side, and have some time left then for committee questions. We have to be on the Senate floor in session at 12 o'clock. So between now and about 11:45, we'll work on this. I would just remind people that if enough people show up that there isn't time for everybody to come to the microphone, Senate rules allow that everyone is allowed to testify either orally or in writing. So anyone that, if there is anyone that doesn't get to speak and they have written testimony to turn in, it'll certainly be welcome to have that. Let's see. There are also, and truthfully, we were sort of anticipating a larger crowd, but if they show up and need and can't all fit in here, there will be TV viewing rooms available in room 405, over by the fan window above the rotunda, and down in the ante room by room 317. So with that, we'll start the hearing on Senate Bill 423. Senator Essman.
Mr. Chairman, members of the Senate Judiciary Committee, before I commence talking about the committee bill that I'm carrying before you today, I wish to acknowledge the hard work of the other members of the subcommittee, Senator Cliff Larson, Senator Chaz Vincent, as well as the work of Legislative Services staff, our committee counsel Valencia Lane, Sue O'Connell, Julianne Burkhart. Appreciate all the time and effort they put in working on this project. What brought us to this day, Mr. Chairman? My name is Jeff Essman. I represent Senate District 28 on the west end of Billings. What brought us to this day? In 2004, the voters of Montana passed an initiative allowing sick and chronically ill people to obtain and possess marijuana for a limited number of purposes. In October of 2009, the Department of Justice, under Attorney General Eric Holder, issued a new opinion that focused their efforts in law enforcement at the federal level and sent a signal that, with respect to states like Montana, of which there are 14, that had adopted by law or initiative provisions for the use of marijuana by its residents, that they would not make them a high priority for prosecution. Since that opinion occurred, there has been an explosion in the number of registered cardholders in the state of Montana. The last number I saw was over 28,000. There has been a creation in many communities of a dispensary system, which means there are storefronts present on commercial streets and byways in Montana that are promoting the use of this product. There are ads on television. There are ads in the newspaper. There are, in my community, there have been potted plants on porches in front of these businesses. There have been painted signs with leaves on windows. There have been billboards advertising a business as the home of the $200 ounce. This understandably has created a severe reaction among the parents and citizens of the state of Montana. The good intentions of Montana voters has been made a mockery by the system that has grown up in this state in the last year and a half. A mockery. And that is what brings us to this day. I will go through the provisions of this, but the goal of this, the overarching goal of this bill is to repeal a system that has been, that is obviously broken, cleanse the system out, and then restore the laws of the state of Montana in a fashion that will recognize the intent of Montana voters in 2004 while removing the air of legitimacy that these dispensaries have attempted to invoke on this product, removing access that has resulted as an occurrence of the development of those dispensaries, removing the profit motive and the incentive to promote the product because of the system that's been established, and return this to a system that's designed to provide a type of therapy for a small number of Montanans. So what does this bill do? Sections 1 through 16 deal with new provisions on issuance of cards. First, with respect to physicians, it requires a bona fide doctor-patient relationship of at least 4 visits over 6 months or more. It requires no physician relationship with any licensed functions. It adopts a minimum standard of care for physician responsibilities with respect to certifications. It requires the Department of Public Health and Human Services to refer physicians who certify 25 or more patients in a 12-month period to the Board of Medical Examiners so that the board will review whether the standard of care is being observed. It requires that a second physician is required for review of severe chronic pain diagnosis and certifications of minors. and sections 42 to 44 of the bill prohibit the use of telemedicine with respect to these certifications. The bill requires that cardholders are Montana residents and sets forth what those requirements are. The bill provides significant new authority to local governments. It allows local governments to control location density with respect to zoning and inspection and business licensing, and it provides that cities and towns have the power to prohibit licensed growers and product manufacturers from inside their jurisdictional boundaries. The bill provides that the Department of Public Health and Human Services would need to issue a new laminated card for registered card holders that they must possess at all times. The bill reduces limits on the number of plants at residences, and the committee intends to bring to the full committee a decision point with respect to quantities that are allowed outside the home. All the duties with respect to the department would be paid for by, with respect to card issuance, would be paid for by fees paid for by the people making application to the department for the registration cards. Section 17 to 40 of the bill create a new system of control for what is a controlled substance that is on Schedule 1 of the Controlled Substances of the United States of America. This bill, and I believe you have a handout in front of you, it should have been handed out, and there are some we're over on the table for people in the gallery that might like to review them, sets forth two different plans for control of this substance. This plan is largely based upon a system that's been in operation in the state of New Mexico for the past 4 years, and I'd like to go over it in detail. So I'm sure the committee and the public understand it closely. As opposed to our current system, which has a definition for caregiver and then allows caregivers to grow on behalf of registered cardholders, and that handout should have a correction that the patients are not licensed, they're registered cardholders. The New Mexico system provides that the registered cardholder can grow and possess at home. The caregiver, which under their system and at this bill is referred to as a personal production assistant, that person is licensed to provide services to the registered cardholder at their home. So the caregiver cannot be a registered cardholder themselves under this approach. They cannot have a felony conviction under this approach. They cannot transport any product under this approach except when called by a healthcare facility to remove it from someone being admitted to a healthcare facility. And the personal production assistant, this volunteer, has to go fingerprint and background check. The bill provides that if there are minors in the home, the registered card holder may not grow marijuana at the home. That element was inserted at the request of constituent in Billings that had dealt with a situation where a sixth grader had clipped leaves off a plant at home. The parent was a registered card holder. The child took the leaves to the school, was selling it in the hallway of a grade school. And when the responsible school authorities intervened to stop that situation, the student could not understand what was wrong. That is the problem with respect to the air of legitimacy, access, and availability that this bill is trying to deal with. The state licensing authority would issue the license for the volunteer assistant. The Department of Health continues to be the registered card holder issuing authority. If you turn to Plan B, this is the alternate control system designed to reduce access, availability, and the air of legitimacy with respect to those registered card holders who, for a variety of reasons, cannot grow at home. Those people are basically in three categories as the subcommittee analyzed. One would be a registered card holder with a minor at home. One would be a resident of a retirement or nursing home that did not permit growing at that residence, or, for example, an apartment dweller where the landlord does not provide written approval. And the the third category would be individuals that just don't wish to deal with the work of growing the product. So how would that provision system work? I think I want to backtrack a little bit to the issue of why the New Mexico model versus another model that the committee looked at, which was the Alaska model. The Alaska model, which has proponents, basically allows for an assistant, the caregiver in their language, to grow and transport to the patient the product. So you can have a grow operation, a transportation function, and then the registered card holder over here. Assuming that the new stricter qualifying provisions in this bill are adopted, and that we end up with a smaller population of registered card holders in the 1,500 to 2,000 area, and that's largely based on conjecture. But making that assumption, let's assume the Alaska model was adopted in the city of Billings, which has 15% of the population of the state and might have 15% of the registered cardholders in the state. Adoption of the Alaska model would mean that there would be 300 locations in Yellowstone County where you would have a grower able to grow the product and then transport it on the streets of the city of Billings in Yellowstone County to the registered cardholder. In our opinion, that significantly increased access and availability of that product to the children of the state and the general population. That is the reason we did not choose the Alaska model. Let's go back to what New Mexico does for those who do not grow at home. They have established a system where they have either two types of licenses. One is for a grower license, and the other is for a manufacturer license, and that would be for edibles, tinctures, topical oils, that type of thing. They provide that both those organizations have to be, they call them nonprofit entities. They were operated by a board of 5 members. They specify who has to be on the board. They specify that the product has to be sold at a consistent price rate, but they do not have any rate making or cost review provisions in their approach. The subcommittee took the New Mexico model and made some additions which we feel creates an even tighter model with respect to access, availability, and legitimacy. The way this model would work is that the patient that desires to obtain product would contact the state licensing authority, who could then provide information to the registered cardholder on who are licensed growers or product manufacturers in their area. The registered cardholder can only purchase or reimburse for cost the product by electronic transfer type means. Cash transactions are prohibited. The licensed grower or product manufacturer would notify a licensed courier, who could be a business. The courier would contact law enforcement to notify law enforcement, I'm going to make a stop to pick up product at points A and B, and I will be making deliveries to points C, D, and E. This is a very transparent system with respect to law enforcement. The committee, due to its desire to remove the profit motive from the production of and distribution system for marijuana in the state of Montana, which we feel is essential in order to stop the incentive to promote expanded use, look to placing the responsibility for this licensing operation, the licensing authority, with the Public Service Commission of the state of Montana. And why did we do that? The Public Service Commission is the only existing agency in the state of Montana that has background with respect to reviewing the cost of inputs. They do that now on a daily basis with respect to reviewing the rates and charges charged by public utilities in the state of Montana. This system is designed to be very analogous to that. So let's walk through the sections here. Section 18 deals with the powers and duties of the state licensing authority. Provides that the licensing authority has the duty and responsibility to establish security requirements for these licensees, background checks, licensing, establishment of fees, adopting an idea suggested by our governor, the use of genetic markers with the plants when that's feasible. Section 19 deals with the licensing authority's authority with respect to couriers. Section 20 sets out the requirements for these new non-profit type organizations with respect to a 5-member structure control, a board, that type of thing. Provides full disclosure of financial interests with respect to these new licenses. Section 21 sets forth the 4 types of licenses the licensing authority would issue: a courier license, the personal production assistant license, that's for the volunteer at home, the grower license, and the manufacturer license. It also sets up a procedure for registrants, and those registrants would include employees of these nonprofit organizations. Section 22 sets forth the requirements and restrictions with respect to the courier service. Section 23 sets forth the requirements and responsibilities with respect to the volunteer assistants. Section 24 sets forth the responsibilities and restrictions on the growers, limits the number of mature plants at a grow operation to 95, provides that the state licensing authority would adopt rules with respect to almost everything else involved with that grow operation. Section 24 also provides that there cannot be any use of the product at a grower location. Section 25 sets forth basically the same type of provisions for the product's manufacturer. Section 26 details the background check, licensing procedures. Section 27 sets forth prohibitions on who can obtain any of these 4 licenses. prohibits involvement, prohibits an individual with a prior felony conviction from obtaining a license. And I want to state on the record that was made with respect to the high interest the state of Montana has and has the power to recognize under our Constitution with respect to public safety. And basically the other persons prohibited with respect to licensees is a fairly long list that you could refer to as a deadbeat list. Section 28 indicates where the state licensing authority shall deny licenses. It has broad power to add rules, to add appropriate restrictions as it sees fit. Section 29 ties into the local government authorities. Section 31 is the section that prohibits cash transactions. Section 32 deals with any transfer of control of any of these nonprofit organizations or couriers. Sections 36, 37, and 38 deal with a variety of boilerplate with respect to inspections, unlawful acts, and penalties. Section 39 was also a suggestion we received from constituents that creates a hotline, an easy method for Montanans that suspect abuse to report a problem. Sections 43 through 60 basically make corresponding amendments to other sections of the law and provide for transition procedures. Those provisions would basically stop the issuance of new cards upon passage under the old system that's in statute now on passage and approval of this act. We intend to amend into this law the repeal of the current Medical Marijuana Act with an effective date of July 1. So that existing storefronts, growers and manufacturers would have effectively, the storefronts would have to close down on July 1, and prior to that time transfer any remaining nursery stock or product to law enforcement. Existing growers and manufacturers would have an opportunity to seek licenses from the licensing authority. They would cease to operate and conduct public business on July 1. Remain closed for 90 days so that law enforcement can make sure that the abuses in the system have been cleansed. And then under a strict licensing regime, they can reopen on October 1 in a transparent method that's friendly to law enforcement so that law enforcement can do its job, which still, and fulfill its responsibility to provide protection to the general public and the minors and children of the state of Montana. I've been asked the question, why this big state licensing authority approach? I want to answer that in a very straightforward fashion. Why this approach versus the Alaska approach? Number one, that Alaska approach, as I said, could conceivably allow 300 grow operations for 300 registered cardholders in Yellowstone County. Unrestricted, unmonitored transportation of product from grower to cardholder. Number two, the most core function of our government, is the provision of public safety. That is why we are here. That is our number one responsibility. Our society has provided for public safety with respect to alcohol, another substance that has addictive qualities for certain individuals. It's provided a public safety control system with respect to pharmaceuticals and drugs. Public safety is an appropriate role for government. It is the most appropriate role for government, and the public safety model is what is adopted in this bill the committee puts forth for you today. So I think I've covered the high points of what our goals and objectives were in this bill. I'll be happy. I look forward to listening to proponents and opponents and responding to questions from the committee. Thank you, Mr.